qualifying for trademark protection requires legal use in commerce. There's no requirement for legal use or any kind of use for a patent. And getting a patent just requires that whatever you're saying you invented actually qualifies as being new, and that it's not obvious, and that it's adequately described. And if it meets the criteria for patentability, it doesn't have to be legal at all.
So I can get a plant patent right now on my cannabis.
Yeah, there are issued plant patents. We've got a bunch of them in the process. There are plant patents that have issued. There are also lots of patents on other things like, different modes of extraction, different ways of processing, different products that contain THC or CBD or other cannabinoids. So it's wide open on the patent side as long as you meet the requirements. And that's the thing that does confuse people, is that same federal agency, two different sets of rules because they operate under two different statutes with different sets of requirements.
So with patent and trademark, like I know Dab Stars, I don't know if you're familiar with them out here in Washington, but Dab Stars, they started out as a t-shirt brand, kind of like what Cookies was doing, a clothing line. They trademarked that. And I know when Dab Stars in the beginning was trademarking it, they were having issues again because they're cannabis related, but they were like, look, we're just t-shirts. We don't do grow. We don't do nothing. And so they worked around that. And now they're actually involved into product branding, but they didn't start out as a manufacturer of it. Is that like a workaround, do you think?
Yeah, I mean, there are a lot of companies that if they want, let's say they've got a brand and they know that they have aspirations for, when there's a nationwide legalization, that they want to have a nationwide brand. But they know that they can't get brand protection for anything that touches the plant right now. They will look for the things that they are doing that are legal that they can associate with that brand, and they'll get federal protection of those things, and then they'll get at least common law protection and often state protection for the things that they can't protect federally. It's more complicated than I'm making it sound, and anybody who is looking to develop a strategy for this really ought to consult with a lawyer who does this.
Yeah.
But that's the essence of it, is that you can kind of create a footprint in the general area associated with the products that this company makes, but you do have to tread carefully.
So say that I make the Mac, Miracle Alien Cookies. Mac Capulator, let's call it, or Catapulter. I'm not sure I've never seen the word catapult pronounced. But so if I made the Mac seed and I'm just like selling this seed like a banshee and people are using that seed in crosses, can I then describe that type of new cross that I've made and get a plant patent on it?
Yeah, if you do it fast enough, if you do it before it's been commercially available for too long. So when you make a new plant variety by making a cross, so you do a cross, then you do a selection,
and you pheno hunt. You might want to clone only,
Yep. But once you've got something that's stable, either it's stable because you're only cloning it and you like the phenotype and you're cloning it, or you've done enough back crossing or inbreeding to get a stable seed line, then you define that as a new plant variety. Having the patent office accept that it's new is usually not a challenge unless there's evidence of public availability. And so you can lose your novelty either by really it not being something that you invented.
True, but think about how rich is the plant in itself in it's genetic expression. And so there's no way that phenotype existed before.
Yeah, you're exactly right. A lot of people think, wow, I don't know if what I have is really new enough to qualify for a patent. And the fact is, the patent office, when it comes to plant varieties, they accept the fact that any cross with all, 30,000 genes or more between two parents, you're shuffling a deck of 30,000 pairs of cards. Yeah. What you get from that shuffling event is going to be new. And the patent office doesn't really push back on that as long as you attest that you really did the breeding and the crossing, or the crossing, you did the cross and the selection. The only way, so the real significant way that you can risk losing your right to patent is if you wait too long to patent if you're selling for too long before you patent. So depending on what you try to patent, let's suppose that you're only selling harvested flower. So you've got a great clone, you've got it in some nurseries, but it's all protected by agreement. You've never sold the plant, right? You're only selling harvested flower. Then that plant hasn't lost its so-called novelty because it's never been publicly available. And making the flower available doesn't make the plant available. A lot of people think that sounds kind of hokey. How could that really be? But I've spoken with the supervising patent examiner at USPTO about that specific scenario, and he said, "Look, if what you're claiming is the plant and it hasn't been available, then it's still new."
Then that just makes me think that all right, if I'm going to do the balance sheet, and I do it, I mean, like if I'm going to do the balance sheet for like an operator and it's going to try to be vertical, on that balance sheet is going to be this item right there regarding the IP. And then you're going to have like vaults for your mother room to a certain extent. It's like, well, do you have seeds for that? Oh, hell no, we don't have seeds for that. Because putting those seeds out there would in theory jeopardize your patent rights.
Yeah, unless you file first. I mean, it's easy enough to just file first, and it's less complicated and it's relatively eí to get a filing date if you're working with somebody who knows what they're doing. It's also easy for somebody to screw it up if they don't know what they're doing. But yeah, I mean, as valuable as these things are, especially a special variety, you don't want to mess around with risking your patent rights.
If you had like sour D, but was it always this way? So like, could we have gotten a patent? I mean, probably expired by now because it's from the mid-90s on like OG Kush or sour D then?
Yeah, I think the thing is back then people they weren't very inclined to trust the federal government, and everybody just kind of assumed that you couldn't get federal rights from the USPTO. But really, if you look at it, USPTO has been granting cannabis-related patents all the way back to the 40s. And there weren't very many of them, and there weren't any on plants. But I think that was really just because people weren't trying to get them.
When a patent for cannabis is done, like for the flower, is it like the DNA is actually like extrapolated and like this is your reference for what's going to be in the court of law?
Yeah, a lot of people ask that, and there are some companies that do really good DNA work and are good at doing a whole sequencing or a DNA fingerprint of a plant, but you actually don't have to submit DNA evidence of any kind to get a plant patent or a utility patent on a plant. If you have it, it can be helpful, but it's not essential. So really what you do when you apply for a plant patent, and this goes back to the fact that the patent statute was started in the 30s before most of these higher tech ways of describing a plant were available. Really what you do is you just describe the cross. You actually take some pictures of the plant, and then you describe the phenotype really thoroughly. You describe all kinds of things about what you can see, the botanical features. And this drives some of my clients nuts because they didn't ever take a botany class. They love the plant, but they didn't learn all the terminology.
That would be hilarious. I mean,
yeah.
Dale, I don't mean to cut you off, but just for the viewers and the listeners at home, think about all the hypotheticals in that. It's like, I like on paragraph 7A, you described it as very terpy. Can you elongate that terpiness aspect? It's like, well, it had this dank aroma. Okay, again,
oh my God,
description dank.
That's exactly right, though. I mean, the people I work with, they know the plant as well as anybody does, and they love the plant, and they could describe it in ways that people would understand the description, right? But it's not technical enough for the patent office, and so we have to drag them through the deep end of botany stuff.
It has to get technical because, like to Tom's point, I mean, I can just like skunk. We learned that they don't have skunks in England, but when you drive past a huge farm, you smell a skunk smell. You're like, it's either weed or a skunk. Right. Couldn't you just be like, smells like horse's ass on a midsummer's day? Is there no like funny shit like that?
Well, I've seen one that's all, I've got the best cat piss weed ever, and it's like, okay. The one way that is kind of standardized and relatively accessible is that I think a lot of states require now a certificate of analysis, and those are pretty standardized. Yeah. And that'll give you a list of the cannabinoids and their abundance, and the terpenes and their abundance usually as a function of dry weight. And we will submit something like that, and that is helpful. But although the examiners still ask in a ridiculous amount of detail on the botanical description, just because that's the tradition for the plant patent statute.
But let's use an example from one of the viewers that is embarking on something like creating a miracle alien cookies, popularly known as the Mac strain. So like they're using a hammer toe line and a duck foot crossed with Freak Show, and he's gotten permission to use from Freak Show. Let's hope that is legally correct. But Freak Show and this what is it called? The duck foot crossed. They create a plant that does not look like weed. I mean, it kind of looks like weed when it's flowering, but if you were walking past it, you wouldn't say that's marijuana, because the trademark leaf has been turned into this weird kind of almost looks like a fern. And because that's such an interesting, phenotype that's out there, if you crossed something with it and it has a different expression, like Purple Freak Show or something, you cross it with a GDP, and that works. Would I then, or would he be able to start the process of filing a plant patent?
Yeah, and this is a really important thing, and it might get a little bit complicated, but it's such an important point I want to make it. You can qualify for a patent if you create something new and original, even if you started with somebody else's material. But that doesn't mean necessarily that you can legally use it, because let's suppose that you didn't get the rights from Freak Show to do that cross, then even if you can qualify for a patent, you still might have an issue with the owner of the Freak Show.
Legality, another legality section of it. Like yes, you created it, but yet you still owe Freak Show another 10% or some sort of agreement that says it can go on the market.
Yeah, and this is an analysis that we talk about with a lot of our clients. There's a difference between so-called patentability, which is your right to get a patent, and so-called freedom to operate, which is your right to actually use your technology. Because I might make some new product, some new let's say something that grows hair out of two different things that are patented. And if I don't have permission to use those patented things, then I could still qualify for my composition because it's new and it does something pretty cool, but I would still need a license from them to be able to use it myself or sell it to people. So getting a patent doesn't mean you can use it.
Well, what could I do this? What if I didn't make that new proprietary thing until 15 years after the patent was identified? And then they sue me and I go, I'm your Huckleberry. And then I just try to twist them up into a lawsuit until the patent expires, 5 years of litigation. I want to depose your mom, it's like, objection. Oh, we're going to go to talk to a judge again, are we? And channel my inner former litigator.
Yeah.
Is that a strategy? Like if suddenly their patent is expired because they only last, how long do they last exactly?
They last 20 years from the filing date. I mean, you can, that's sadly not uncommon that people will, they will make a calculation about when it is they can start infringing. Now, of course, if you start infringing when there's 5 years left, you could drag out the litigation, you'd still be on the hook for the 5 years of infringement before it expired.
Oh, wow.
But part of it depends on how well prepared the patent owner is to actually withstand the litigation. And
correct.
I encourage people to look at getting insurance for that kind of thing so that they don't have to derail their whole business to do that.
Because court litigation is very expensive. Yeah. What
I missed that. What'd you say?
I said that litigation is very expensive, but then Miggy has a question. So.
Oh no, I was agreeing with him. I had the same statement. A statement that was the same thing you just were getting to, Tom. But I was just wondering, how deep does a patent go? Like, does it go to the sauce, like to the recipe, to the soil, and nutrients, and like the, as we were talking before about appellation, or before, it's always a topic. How deep is the patent go for cannabis?
It really depends on what you're trying to protect. If you're just trying to protect a new cross, then you certainly are supposed to describe where and how you grew it and so on. And you're not required to recite all the soil conditions, and you're certainly not limited to those soil or grow conditions for protection. On the other hand, let's suppose that you find that there's a particular way of growing something that makes one terpene just go off the charts. And that's what you want to patent. You want to patent, hey, I've found a way to make one terpene really dominant in a lot of different genetic backgrounds. Then if that is a cultivation technique, you'd have to go into a lot of detail about that cultivation technique, and you'd have to show that you really can do that in a bunch of different genetic backgrounds. But if you could, and it really was new, you may well probably would be able to get a patent on that.
Nice.
Yeah, but then how much are patents worth? That's something that I also want to make sure that when I'm talking to growers, because I didn't know, I've been advising them the opposite, like, you can't get it patented. Hold the presses. Dale says we can do it. He's got a JD from Berkeley and a PhD from the University of California, San Diego. I think we can do it. So that's great. I mean, that's gives a huge sigh of relief to so many operators that are coming online thinking they're going to have proprietary genetics that are worthwhile.
Yeah, and how much patents are worth really it's a hard question to answer unless you can look at some data points. And so there's this company called EBBU, EBBU, that amassed a pretty decent collection of patents. They weren't on plants specifically, but they were on related to cannabis, I think some genetic things. And they were purchased by Canopy Growth for $330 million, and pretty much the only asset they had, well, the major asset they had was their patent portfolio. And they didn't have, I mean, they had, I think, a few dozen patents. So
Wow.
That's one sign that, all right, if your patents occupy the right space and there's a lot of value around them, people do value that. I think Canopy was looking for a way to get into the IP business and jump into the deep end of it. And that's one transaction that happened. Just as another example from another industry, I worked with a startup company that started when they had just one patent application that was pending that they licensed from a university. They did a lot more R&D, and we put together a nice patent portfolio for them. And a few years later, maybe 4 or 5 years later, they did an IPO in an initial public offering that raised about $120 million. And again, that was almost all the value. It was almost all of that value came from their patent portfolio. One other way to look at it is, let's suppose you look at, let's say, some really valuable cannabis variety that everybody uses, everybody loves, everybody grows, and you look at what it would be worth now if somebody could rewind and get a patent on that. And one thing I just want to say, this is a little bit of a tangent, but I think it's really important. I was talking to somebody about patenting plants, and they said, doesn't that just limit access? And in my experience, it actually makes the access more available, because when someone has something really special that is easy to copy, they are actually going to be pretty cautious, at least in many cases, they're going to be pretty cautious about letting people grow that, letting people have access to it. On the other hand, I've got clients that have some really special varieties of fruits and flowers that are licensed all over the world. They're accessible in so many markets because since they have patent protection, they're willing and able to make deals around that without losing all the value. And they take a pretty modest royalty in order to be able to take advantage of that large scale. And so if you, let's say you have a medicinally really important plant, I think having
Like
IP
cannabis.
protection on it makes, it's certainly like cannabis. I was thinking of, if you had one that had one variety of cannabis that had great value.
Like a Charlotte's Web?
If you didn't patent it, you'd be always stressing about who's growing it and what they're doing with it. If you did patent it, you could license it out as widely as you wanted, and you would know, as long as you did it right, the licensing has to be done correctly, but you'd know that you're still going to be in control of that, and that it's not going to have a bunch of counterfeits and a bunch of unauthorized, a bunch of pirated plants out there. So I think the potential for abuse comes if you're charging a ridiculously high license rate, but that's where the market comes in and pushes back on it. And I think that if you charge a fair license rate, that patenting really does make plants like this more available to the public.
You know, go ahead, Tom.
Oh, no. That was going to be like an anecdote that's related to the original question of how much is a plant patent worth for your particular cannabis. It's a lot like how much is your copyright worth. So your copyright for like the movie Gone with the Wind. way up here. Well, maybe now, of course, it's gone down, but for decades, people wanted to see Gone with the Wind. Now, I'm sure that there was also a movie made around 1939, Reefer Madness. Way less money, right? Like nobody wants to see that. It's if they want to see it, they want to laugh at it. They don't want to pay to see that. It's a piece of crap, you know. And so it depends on like what type of market intangibles that go beyond the patent itself, the qualities of the plant, or the marketability of or how the market, because like cookies as a marketing strategy worked really, really well, and so it would have inflated the value of that patent.